Thank you all for coming. My name is Rachel Brand. I'm the chairman of the Litigation Practice Group of the Federalist Society. I want to welcome you to this panel. My job here is simply to make a plug for your involvement in the practice groups of the Federalist Society. As some of you know, most of the programming at this conference and in general of the Federalist Society is done by the practice group. So this panel is planned by my practice group, the Litigation Practice Group. The Hobby Lobby panel this morning, for example, was planned by the Religious Liberties Practice Group. And so we would love to have your involvement in one of those practice groups. We'd love to have your help with the programming and any other way you want to pitch in. So if you're interested in something like that, come see me, come see one of the staff of the Federalist Society or one of the other chairmen. I'm very excited about this panel. I'm very proud of the panel that we put together and have some old friends here on the panel. And so with that, I will turn it over to Justice Willett.
Thank you for that warm smattering of applause. I appreciate it. This panel, good afternoon, everybody. I'm Don Willett. I'm honored to join you from Austin, Texas. It's not often you get to fly from one nation's capital to another, so I'm honored to join you. As I was leaving for the airport yesterday, my 5-year-old daughter, Genevieve, she whined, "Daddy, where are you going? Daddy, what are people going to be talking about?" And I knelt down and I looked her in the eye and I gently answered, "Genevieve, baby, do you think it's time to revisit Chevron Deference?" And her big green eyes, widened, and she grabbed my leg really tight and she answered, "Daddy, do we have any bacon?" Genevieve is a smart little girl, because Chevron Deference is kind of like bacon. Some people like their Chevron Deference rigid and crisp. Other people like it a little squishy and a little bendable. A few people dislike it altogether, no matter how it's served up. But Chevron is now 30 years old, older than a number of people in the audience today. And a lot has changed. The regulatory state has exploded in terms of size and scope over the last 30 years, becoming arguably a fourth branch of government altogether. So is it time to revisit and think anew about judicial deference to agency decision-making? Do Chevron's virtues outweigh the vices? Have courts gone too far? Has Chevron deference devolved into Chevron dereliction? Are courts moving increasingly from adjudication to abdication, letting the foxes guard the agency in-house? So it is a thorny question that vexes the court, and not along the usual ideological lines. We have 3 former administrative law professors on the U.S. Supreme Court. They have very fervent, strongly held views on Chevron and Chevron deference. And the court is going to have, undeniably, some pretty high-profile opportunities in the near term, I believe, to revisit and possibly recalibrate Chevron. So our 4 impressive panelists are going to help untangle all this. I'll keep the introductions mercifully short. They'll each speak for about 10 to 12 minutes, either where they are or at the podium, whatever they prefer. And then we'll have an opportunity for some inter-panel rebuttal, and then we'll open it up, as we always do, for audience Q&A. The microphone is kind of hard to see with that bright light. It is in the middle of the ballroom, right there, so please go there and not just stand up so we can get you recorded. Batting leadoff, on my right, Professor Amy Wildermuth, professor of law at the University of Utah, where she teaches and writes on civil procedure, administrative law, U.S. Supreme Court practice. She has more degrees than a thermometer I've seen. She has an A.B. in history and a B.S. in engineering and policy from Washington University in St. Louis, an M.S. in environmental engineering, and then finally a law degree from the University of Illinois. So 4 degrees and 3 clerkships. She clerked for Judge Calabresi on the Second Circuit, Judge Edwards on the D.C. Circuit, and finally for Justice Stevens on the U.S. Supreme Court. To her left is Charles Cooper, familiar face to a lot of us here, founding member of the Washington, D.C. law firm Cooper and Kirk, named by the National Law Journal as one of the 10 best civil litigators in Washington, over 30 years of legal experience in government and private practice, with several appearances before the U.S. Supreme Court. Chuck was a law clerk to Judge Paul Roney of the 5th Circuit, now the 11th Circuit. This was pre-split. And then for then Justice Rehnquist on the U.S. Supreme Court, and then went to the Justice Department in the Civil Rights Division. And then in '85, President Reagan appointed him to head up the Office of Legal Counsel there at DOJ. Chuck's trial and appellate practice is national in scope. It really covers the entire gamut. It is concentrated a bit in the areas of constitutional law, commercial law, administrative law, healthcare, and civil rights litigation. Third, Professor Jack Bierman, professor of law at Boston University School of Law, which he joined the year Chevron was decided in 1984. Professor Bierman, clerk for Judge, pronounce this for me.
Which part of Wisconsin are you from? Cudahy.
I'm from deep south Wisconsin, as in Texas. Cudahy, of the U.S. Court of Appeals for the 7th Circuit, co-author of at least, by my count, 4 books on administrative law, including a widely used leading case book, and to the joy of a lot of law students, the Emmanuel Law Outline for administrative law. In his spare time, well, before I get to that, he's been published virtually everywhere, not just in America, but all over the globe, on administrative law, on civil rights. He's lectured in numerous countries throughout the world. But in his spare time, he does umpire high school and youth baseball games, where no doubt the fans give you just unlimited deference, I'm sure, right? No second guessing at all. All right. Finally, Professor Thomas Merrill, the Charles Evans Hughes Professor of Law at Columbia Law School. Before that was on the faculty at Northwestern and Yale Law Schools. Former Deputy Solicitor General from 87 to 90. He has taught administrative law for many, many years and written extensively about the Chevron doctrine, among other topics. So, Professor Wildermuth, if you want to start, you can stay where you are or come up here. I defer.
Thank you so much. It is great to be on this terrific panel. And I have to say, after a long flight from Utah that I got off of about an hour ago, it's nice to stand. So I am going to stand for a little bit. My job, I think, is to set the stage here for this panel. It's a little interesting because my most recent work is on Auer deference, which is going to come up in just a second. And I'm going to try to tie all the deference doctrines together. But as any good administrative law professor will do, we should start by sort of setting the stage and talking about all the deference doctrines. Before I talk about that, I think what will be important to take away from what I have learned are the historical background that I think we sometimes skip over when thinking about these doctrines. So that's where I'm going to come back to, and I am going to give you a little hint to where we're going to end up here. It concerns me, it deeply troubles me from what I've discovered. So here's the brief review first. So when I teach this, right, we talk about the 5 deference doctrines in administrative law, 2 of which we get out of the APA, the arbitrary and capricious standard and the substantial evidence standard. I'm going to set those to the side for right now, and I'm really going to talk about the 3 judicially created deference doctrines, the Chevron doctrine, the Skidmore doctrine, and Auer. And so Chevron, we all know, is the deference that's afforded to interpretations of statutes that have the force of law. I'll spend a little more time on that in just a second, but we all know this is a Chevron 2-step, right? And I would presume that you would not all be here if we didn't remember what that 2-step was. I usually do a dance right now in my class. The no, okay. All right, so how about Skidmore, right? So the recently revived, although not so recent now, Skidmore doctrine, which applies to interpretations of statutes that don't have the force of law. And just so we all remember, right, it's a sliding scale of deference here. It's determined by the thoroughness evident in its consideration, the validity of its reasoning, this is the interpretation, right? Its consistency with earlier and later pronouncements, and all those factors which give it the power to persuade. And then finally in this constellation, we have Auer deference, which is the deference afforded to an agency's interpretation of its own regulations. This has, of course, been of some interest now since the Decker case. I happen to be a part of one of the briefs that was cited by Scalia and by Chief Justice Roberts, talking about sort of the concerns with respect to Auer deference, right? And this is the deference, we will provide this deference to an agency's interpretation. It will be given controlling weight unless it is plainly erroneous or inconsistent with the regulation. Okay, so at this point, when I go through all three of these, and I try to do a dance, right, but all my administrative law students just sort of zone out, right? And I can imagine that that might be the sense that you're having, like, really? Do we have to go through all those details again? And in fact, what this has prompted lots of professors to talk about is whether this should be simpler. And the two that come to mind here, Professor David Ziering and Richard Pierce, for example, have looked at the rates of deference under each of these doctrines, and with one notable exception, have found that courts defer in about 70% of cases, no matter what the doctrine is that is to be applied. And of course, the exception here is my Auer deference in Supreme Court. The Supreme Court seems to really like Auer deference. It's at about a 90% rate. But this then prompts the question as to why we would spend time on a panel like this thinking about and digging deeply into Chevron deference. The idea is, right, that the court should just accept the reality of these figures and adopt a single rule of reasonableness, or at least we should understand it as that. Now that would certainly make life a lot easier. It would be easier to teach. I could take a couple classes off, right? My students would really like that. But I don't think that that's as easy to swallow as it first appears. For me, the real turning point has been this project that I've spent about a year now working on, looking at all the lower court cases from the time Seminal Rock was decided, and then it was transformed into Auer, and sort of trying to trace that history. And I think when you spend that time looking through all of those cases, you discover some interesting things. And in particular, you discover an interesting thing about the evolution of some of these doctrines. So each of the three doctrines, I'll just remind everybody, has sort of really early roots. In particular, Skidmore, and then the case that I, as a former Justice Stevens clerk, often associate with Chevron as the ancestor, right, to that case is NLRB versus Hearst, were both decided in 1944. Seminal Rock was decided in 1945. And of course, this was a really formative period in the time of administrative law. We have the APA being passed in 1946. And importantly, agencies looked very, very different, as Justice Willis started us off, right? They looked very different than they look today. So the context and what was going on at that time turns out to be very important. So we look at these three doctrines, and you can find sort of an interesting historical story to be told for all three of them. For the purposes of this panel and for time, I'm going to focus on Chevron and Auer and the sort of history that I think they share. So as Professor Merrill and my good friend Catherine Watts have explained in their terrific article that came out in the Harvard Law Review more than 10 years ago now, which, by the way, Justice Stevens was very proud of, even though it told him he got Chevron wrong. He was still equally proud of Catherine. They've explained, right, that there was a very specific understanding, a convention regarding what when Congress intended to give an agency the power to act with the force of law when issuing regulations. It turns out that in our work on Seminole Rock, we also have some similarities, right? We have Seminole Rock emerging from a time where agencies were more limited. We have, in particular in Seminole Rock, OPA, which was one of the few agencies that was given rulemaking power. It was in a time of war, and it was doing price controls, which we do a lot of now, no. So it has a very unique sort of history, right? And in addition, if you take a close reading, I would encourage all of you, go back and read Seminole Rock, right? It makes clear that the deference was only arrived at after the court had done an independent judicial check on the language of the regulation and was satisfied that the interpretation was appropriate. So part of this is because there was so little rulemaking at that time, right, in the sort of 40s and into the early 50s, there were relatively few cases that raised Seminole Rock or even the question of the convention with respect to Chevron. But then, very interestingly, in the late 50s and 60s, there was great enthusiasm, a big push for rulemaking. And again, as Professor Merrill and Watts explored in their piece, we know that there was a collective memory loss regarding the original convention with respect to laws that were giving agencies the power to act with the force of law. Well, it turns out we have the same thing happen with Seminole Rock. Seminole Rock had very modest origins. And then around this same time when we have a push for rulemaking, it is not surprising that once you start making more regulations, you have more agencies going in and asking for deference to their interpretation of regulations, and all of a sudden you lose the roots of Seminole Rock. So this is a really important, critical time, right, in these deference doctrines, and for me, it makes a difference to how I think about the issues today. This matters, right, because that sense that there might be something wrong or something amiss in applying these doctrines is confirmed when you think about their development. That is, questions that might be raised about the doctrines, the questions that the panelists today are going to raise, questions about separation of powers, delegations of Congress, right, the fundamental due process considerations. I think those all start to make more sense when you think about the gaping holes. And I think they're gaping. I think they are very big holes in how these doctrines developed over time. So if you can't get from point A in the mid-1940s to point B in 2014, I think it should not surprise us that there could be significant issues and questions that just were left unresolved or unaddressed. And in fact, that's what we see, right? And especially in my work with respect to Seminole Rock, you have all kinds of cases that just sort of turn, and it's remarkable, right? The difference between the language used in sort of the late 40s, early 50s, and then you get to the late 60s and you think, is this the same court? And in some instances, it's the same judge. No explanation. For me, it seems only fair to suggest that the courts, and I'm going to use this, I hope people will get this reference. I now figured out that I've aged out of like cool in my classes, but that's okay. That's okay. I'm handling it. But anyway, right, in the words of Ricky Ricardo, right, I think the court has some explaining to do. So with that, I will turn it over to my fellow panelists. Thanks.
Well, good afternoon, ladies and gentlemen. It's a real honor for me to be on this panel with three very renowned administrative law professors, one of whom, at least, is a pretty stylish dancer, I see. I don't know about you guys, probably not. But I have to confess I'm a little bit intimidated. I don't study administrative agencies day in and day out like my colleagues here. I sue them. and I like doing it. So it won't surprise you probably to hear that I think it is high time that Chevron was reconsidered. And that is happening broadly now in forums like this one, and also in the United States Supreme Court, it appears. Chief Justice Roberts, in his dissent in the City of Arlington against FCC case, recently lamented the danger posed by the growing power of the administrative state, and that's a danger to liberty that the separation of powers was designed to protect against. And he emphasized that the framers could hardly have envisioned today's vast and varied federal bureaucracy and the authority administrative agencies now hold over our economic, social, and political activities. Well, none of that is surely true, and nor could the framers have envisioned, surely, the wholesale divestiture of constitutional powers, both legislative and judicial, that has created the modern administrative state. I'd like to focus our reconsideration of Chevron on the Constitution, and in particular on the Arlington against FCC case. The court in Arlington held that when a statute is ambiguous on whether a certain substantive issue has been committed to agency discretion, that is, whether the agency has authority from Congress to resolve the issue with the force of law, the courts must give Chevron deference to the agency's resolution of that ambiguity concerning the scope of the agency's own authority. The court divided on unusual lines, with Justice Scalia writing the majority opinion and Chief Justice Roberts writing a dissent in which Justices Alito and Kennedy joined. I think that Justice Scalia got it wrong and that Chief Justice Roberts got it right. And my view on this follows from three premises, which I think follow from this constitutional separation of powers. First, the question whether Congress has committed, that is, has delegated, a particular substantive issue to agency discretion is a pure question of statutory interpretation. Second, construing a federal statute in a final, binding way is an exercise of exclusively judicial power. As Chief Justice Marshall famously put it, it is emphatically the province and duty of the Judiciary Department to say what the law is. Third, an administrative agency has no power, no judicial power, to construe a federal statute with a force that is binding on an Article III court. The Constitution does not grant such judicial power to administrative agencies, and such a judicial power cannot be delegated to an administrative agency by Congress or by the courts. Accordingly, a court is not required, indeed it is not permitted, to defer to an agency's decision on whether the agency has statutory authority to decide a particular substantive issue under the statute it administers. In reconsidering Chevron, it is first critical to understand precisely what kind of power, legislative or judicial, an administrative agency exercises when it decides particular substantive issues. The Supreme Court's Chevron decisions, including Chevron itself, are deeply muddled on that question. And the opinions in the Arlington case, both the majority and the dissent, are the latest examples of that confusing muddle. Justice Scalia describes the Chevron rule as follows: statutory ambiguities will be resolved within the bounds of reasonable interpretation, not by the courts, but by the administering agency. Well, now that certainly sounds like the agency is exercising judicial interpretive power. But elsewhere, Justice Scalia says that Chevron prevents judges from substituting their own interstitial lawmaking for that of the agency. Well, that certainly sounds like the agency is exercising legislative power. Finally, Justice Scalia says that the typical Chevron question, that agencies must routinely resolve is how best to construe an ambiguous statutory term in light of competing policy interests. Well, construing ambiguous terms sounds like a judicial function, but deciding between competing policy interests is certainly a legislative power. So from this passage, it would appear that the agency is exercising a strange mix of both powers simultaneously. The Chief Justice's dissenting opinion is similarly confusing. Chief Justice Roberts explains, for example, that under Chevron, courts defer to an agency's interpretation of law when and because Congress has conferred on the agency interpretive authority over the question at issue. Well, that certainly sounds like the agency is exercising a strictly judicial power conferred on it by Congress. Now contrast that statement with the following statement by the Chief Justice. Before a court may grant Chevron deference, it must on its own decide whether Congress, the branch vested with lawmaking authority under the Constitution, has in fact delegated to the agency lawmaking power over the ambiguity in question. Well, that makes very clear that the agency is exercising legislative power delegated to it by Congress. Finally, Chief Justice Roberts, very much like Justice Scalia, also suggests an agency is simultaneously exercising both legislative and judicial power. Here's one such statement among many. An agency's interpretive authority entitling the agency to judicial deference acquires its legitimacy from a delegation of lawmaking power from Congress to the executive. I think it's important, I think it's constitutionally important to try to clear up that confusion. I believe that Chevron's rule of judicial deference to agency decisions can be sustained, if at all, only if the decision-making power exercised by the agencies is legislative in nature rather than judicial. And I think this is so for a number of reasons. First, the essential rationale under Chevron for the rule of deference to agency decisions is intelligible only if the agency is exercising legislative power delegated by Congress. Indeed, the Chevron court itself explained agency power to decide particular substantive issues as necessitated by Congress's decision not to decide them itself, that is, to make no law. This is what Chevron said: the power of an administrative agency to administer a congressionally created program necessarily requires the formulation of policy and the making of rules to fill any gaps left implicitly or explicitly by Congress. And the Chevron court described the role of agencies as reconciling conflicting policies and resolving the competing interests which Congress itself has not resolved. Finally, the Chevron court noted the necessity for agencies to be able to change their statutory interpretations. As the court put it, the agency, to engage in informed rulemaking, must consider varying interpretations and the wisdom of its policies on a continuing basis. These passages from Chevron describe how legislators make law. It is the antithesis of how judges interpret law, at least genuine judges. There's an even more fundamental reason why an administrative agency can exercise only legislative power and not judicial power. It's a very hard question, I think, from an original meaning standpoint, whether Congress can delegate its legislative power to an executive branch agency. And on that subject, I refer you to a recent provocative book by Professor Philip Hember entitled, "Is Administrative Law Unlawful?" But even if one assumes that Congress has constitutional authority to delegate a portion of its legislative power, at least that is a power that it has. Congress surely cannot delegate a power that it does not have. And it has no judicial power to delegate to the administrative agencies at all. So notwithstanding the frequent reference by the court in Chevron and Sense to congressional delegations of binding interpretive authority to agencies, there can be no such delegation, I submit to you, because authority to make final, binding statutory interpretations, that is, authority to say what the law is an exclusively judicial power. And Congress surely cannot make the Supreme Court subordinate to administrative agencies in saying what the law is. Congress has express authority to create such inferior courts as it may from time to time ordain and establish. But even as to such inferior courts, Congress cannot imbue their statutory interpretations with an authoritative quality that is binding on the Supreme Court. That is, a quality that requires the Supreme Court to accord deference to any reasonable interpretation, even if it is not, in the words of Chevron, the reading that the Supreme Court would have reached. If that is true, then it would seem to follow that Congress cannot delegate to unelected bureaucrats or even to the president a genuinely judicial power to say what the law is. Professor Cynthia Farina asked a few years ago, could Congress enact a statute requiring the Supreme Court to defer to the Solicitor General on interpretations of ambiguous federal laws, so long as it was reasonable? For the agencies are truly supreme over the Supreme Court if in fact that power, that judicial power, exists. So what does all this mean in the context anyway of the Arlington case? Well, I think it means at least this. When it comes to resolving the purely legal question whether Congress has delegated to the agency lawmaking power over a particular question, the agency's view on what the law is on that issue of statutory interpretation is not entitled to judicial deference, and in fact cannot constitutionally be accorded judicial deference by the court. I want to make one final point. I think that the Arlington decision has planted the seed of a revolutionary change in Chevron's canonical, as Justice Scalia put it, two-step formulation. Because I just don't see how step one can survive in its current form anyway, the Arlington court's holding that a court must defer under Chevron to an agency's interpretation of a statutory ambiguity that concerns the scope of the agency's statutory authority. Remember that the question at step one is whether Congress's intent on the specific question at issue is clear and unambiguously expressed. And the answer to that is no. That is, if the statute is ambiguous, then the agency, rather than the court, is entitled to resolve the ambiguity. In other words, the existence of ambiguity in the statute is the source of the agency's authority to resolve the ambiguity. But the question whether the meaning of a statute is ambiguous is itself often ambiguous, and therefore is one on which reasonable judges often disagree. The federal reporters are filled with divided courts on Chevron step one. So it follows, it seems to me, from Arlington, that an agency's determination that the statute's meaning is ambiguous is one which courts must defer, even if they disagree, unless the agency's determination is unreasonable. In other words, it appears that Arlington has merged Chevron steps 1 and 2. So with that, I'll turn it over to my other panel members. Thank you.
Great, thank you. Thanks very much. It's really a pleasure to be here. I haven't been at a Federalist Society meeting in a long time. I think it was the early 1980s when I was a student at University of Chicago Law School. And Robert Bork, I remember, was on one of the panels. It was the only time I had the privilege of meeting him. And he was amused at my name tag, which I had written Earl Warren on it. So that's where I was on the, Now, listening to Chuck's presentation, I was wondering if maybe I was in the panel that I really wanted to go to at this time on separation of powers, but I guess it turns out that everything revolves around separation of powers. But I have written a little bit on what's wrong with Chevron. What's wrong with Chevron has always been pretty much wrong with Chevron, although it's gotten worse as time has gone by. Attacking Chevron as a matter of legal craft is like shooting fish in a barrel. It's one of the easiest targets in history of the world because it's really very difficult to figure out what Chevron really is about. Is it about interpretation of statutes? Is it about policy decisions? Just what is it about? And to think that we've had the case around for 30 years and we still can't figure that out, I think says a lot about what's wrong with Chevron. I don't think what's wrong with Chevron is a separation of powers matter. I'm going to get to that later. Although I respect Chuck's views and he's really expressed them very eloquently, I really don't think that there's a separation of powers issue going on here at all, but I'll explain that a little bit later. Now, there are some, just to illustrate a little bit about how Chevron works, I thought about, Gary Lawson and I are sharing an office this year because we're in temporary offices because of a construction project. And some of you may know Gary. He was one of the founders of the Federalist Society, and Gary is one of the funniest people you'll ever hear speak. Anytime you give a chance to hear Gary speak, and it's not too often because he doesn't like to travel, but he always has a great way of approaching something. So I'm trying to channel him a little bit, and I'm thinking about what Chevron is like. Think about it's Christmas morning, and you've given this great big toy in a box with 1,000 parts to one of your children, and of course you got to put it together. So you open it up, and there's this book of instructions that was translated by someone who really wasn't a native English speaker, and the pictures are pretty much indecipherable, and there's 1,500 parts, and you're working on it, and you're grunting and groaning and huffing and puffing and sweating, and it's 3 hours later, and it looks like maybe the thing is put together right, except that you have a whole handful of parts still in your hand. So you got to know, as a lawyer, you have to know like the rudimentary thing about how to do this, or you'll never get it even close to right. But you can't actually solve the whole problem using Chevron in any case, because Chevron basically means whatever the particular court or the particular judges at the particular time want it to mean. And the great divide that occurred with Chevron happened between the first Chevron case and a very close follower case, and it had to do with a footnote that Justice Stevens put in the original Chevron case. And I'll just try to explain that briefly. But the original Chevron said basically that if Congress had directly spoken to the precise issue in question, that was the end of the matter and everyone was bound by that. But if Congress had not directly spoken, then it was ambiguous. We presumed there was a delegation. I don't have to tell you all this. And then you go on to step 2, which is there a permissible construction? He had a footnote, I believe it's footnote number 9, which said, of course, issues of statutory interpretation are for the courts to decide. Okay? So what was that whole step 1 about? And in a later case, the Cardozo-Fonseca case, the court elaborated that in deciding what a statute means, you use the traditional tools of statutory construction. And that means like canons of construction, like those, my favorite is Nasus or Asosis. And whatever you look at, except for Justice Scalia would never look at legislative history, but every other tool of statutory interpretation is open. Now, the court didn't make it clear if that was about Chevron step 1 or if that was about some pre-Chevron notion, as Chuck was talking about, where we have to figure out if the agency's been delegated authority. But it seems like in later cases, the court has said, and the lower courts have picked up on this, that in step 1, in trying to figure out what the statute means, you can use all the traditional tools of statutory interpretation. And only when you can't answer the statutory question do you then get to step 2. Now it seems like what did we gain by having Chevron then? And I think maybe billable hours for attorneys arguing about Chevron is about the only thing that we gain. And in fact, I know that's a good one. And in one of my articles, I wrote an article which was much too long, and it could have been even longer, except that they now have word limits on law review articles in a lot of journals. I said that basically every moment that's spent arguing about whether Chevron applies, and if so, how it applies, is just wasted effort for the lawyers, it's wasted effort for the judges. They should just talk about the case. What does the statute mean? What is our best sense of what Congress meant? And if Congress meant to delegate decision-making authority to the agency, then is what the agency did within the scope of review that applies to that particular case, whether it's arbitrary capricious or substantial evidence or de novo, if it's a case where de novo applies, or whatever. Now, if you look at how Chevron has been handled by the courts, you get a pretty good idea that Chevron isn't really what decides any cases. And there's two things that I want to talk about there. In my two articles about Chevron, I just counted up decisions. So who do you think defers to the agency on the Supreme Court the most? Of all the justices of the Supreme Court, who do you think defers the most? The most is Chief Justice Roberts. Used to be Roberts and Alito were sort of tied. Now, I'm not counting Justices Kagan and Sotomayor because they're too new. And they're off the charts in terms of how much deference, but it's not surprising because they're still deciding cases by the agencies controlled by the president that appointed them. But who do you think defers the least? You can give the same answer that you just gave about who you thought defers the most. Justice Scalia defers the least. That's because Justice Scalia, applying the traditional tools of statutory interpretation, mainly the plain meaning rule, he is more confident in his ability to read statutes than the other members of the Supreme Court are. So he said this, it's not like I'm not putting words in his mouth. He says, I'm good at figuring out what statutes mean, so I'm going to figure out what they mean in step one. So what happens on the cases, if you look at the cases, is that in most of the cases, the votes line up how you would expect them to line up, whether Chevron existed or not. That is, in the 5-4 cases where Chevron is applied, Justice Kennedy decides which side wins. Whichever side he's on, it's those 4 plus him, or the other 4 plus him. It's pretty rare that the lineup gets mixed around the way it got mixed around in the City of Arlington case. Usually, if it's a 7-2 case, it's always 2 on the way extreme on one end or the other. So, but the movement has nothing to do with how they think Chevron applies. It has to do with what they think of the merits of the case, usually along the liberal-conservative spectrum. That's how our judges decide cases, and when Chevron applies. So, so I think that's a good illustration if you look at the actual cases to say how contentless Chevron is. Now, the other thing, there's a little-known case that's come up to the Supreme Court you might have heard about whether certain people can get subsidies for their health care. That's a sort of an unknown one. It's snuck under most people's radar. And the D.C. Circuit has that same issue on bank going on. And if those cases were decided under Chevron, in both of those cases, both sides, the challengers and the government, argued that the case should be decided under Step 1 based on clear statutory meaning. Of course, diametrically opposed clear statutory meaning. And the D.C. Circuit decided that it was clear statutory meaning against the government in its panel decision. We're waiting to see what the en banc court is. The Fourth Circuit decided that based on the entire structure of the statute and the history and the purposes, all those traditional tools of statutory construction, that it was ambiguous. And then the court decided that the government, in light of the purposes of the statute, the government's interpretation was, and now I'm going to quote the 2 words, entirely sensible. Not the permissible construction, but entirely sensible. And that says another thing about the way that our courts function, which is that they set up rules of decision and then they don't follow them. They say whatever they want in any particular case if it sounds good in the opinion. And instead of applying the directly spoken to the precise question at issue when it became better to say traditional tools of statutory construction, they said that. When they had permissible construction, now it's entirely sensible. It's whatever courts think is the reasonable way to do it. In other words, you could take Chevron totally out of the mix and it's just a traditional judicial opinion. In thinking about the failure of Chevron over the 30 years, think about other legal standards that are designed as decision-making processes rather than substantive rules. Think about, for example, how you decide whether there's an entitlement. You use the entitlement theory that the Roth case came out with about is there a legitimate expectation or legitimate claim of entitlement. Think about equal protection law with the 3 tiers of scrutiny. Imagine if today, after all these years, we didn't know how to figure out if someone had a property interest, or if we couldn't even figure out what tier of scrutiny do we apply to what kind of case? Like, is it race discrimination? Is that middle scrutiny? Is that higher scrutiny? Those kind of rules are pretty good rules in terms of they frame the discussion. Chevron doesn't frame anything, so that you even have one justice on the court that says there's only one step in Chevron. That's Justice Scalia. And some scholars have said that's true. There's only one step in Chevron. So we don't even know how many steps are. Some people say 1, some people say 2, some people say 3, some people say 4. Okay? And if you don't know about 4, I have an article where I explain what the 4th step is. Okay? Now, And the last thing I'll say about this before I go on to the Arlington case and the separation of powers is that, to me, the best illustration of the failure of Chevron is Justice Stevens' last Chevron opinion. I believe it was his last opinion. It was in Negussi versus Holder, where the Supreme Court decided the case based on Chevron and deferred. And Justice Stevens dissented, and he said, this was an issue of statutory interpretation for the courts to decide. It shouldn't be decided under Chevron. Okay? There we go again. What is it about? Is it about deference to policy? If it was about deference to policy, you'd think we'd be using the arbitrary capricious standard. In fact, the court has said more than once that step 2 of Chevron is the same thing as the arbitrary capricious standard. But they're totally different. So what do they mean by that? Okay, that's enough beating up on Chevron, poor Chevron. So now I want to talk about why I don't think that the city of Arlington is really a chink in the armor of Chevron, or that it violates separation of powers. And I just want to start with one question, which is there a right to judicial review of rules? Is there a constitutional right to judicial review of rules? Does it violate separation of powers when Congress makes an exemption from judicial review? Justice Scalia would actually lean the other way. He'd say judicial review may violate separation of powers because it takes away from the president's ability to faithfully execute the laws. And I think Gary Lawson also agrees with that. There is no constitutional right to judicial review of agency action except when agency action is in adjudication of private rights where there might be a problem with Article 3. Let me repeat that. There is no constitutional right to judicial review of agency action, period. So what that means is if Congress said no judicial review at all of any of these rules, we wouldn't have to ask whether Chevron applies to jurisdictional rules or not. There just wouldn't be judicial review. Now, when Congress passes a statute delegating authority to an agency, it cannot delegate, I agree with Chuck, it cannot delegate judicial power, and it also cannot delegate legislative power. What it does is it delegates power for the executive branch to execute the law. All the executive, and this is what Justice Scalia said in the Whitman versus American Trucking case. The executive branch can only execute the law. They can't legislate that. Only Congress can legislate. They can't adjudicate. They can't use the judicial power of the United States. Only federal judges can do that. But what they can do is they can execute the law, and they can use different kinds of procedures. And let me just give a simple example. Suppose you have to apply for a permit for grazing in some federal land. Okay, and there's a certain factual standard. You have to meet certain requirements, and the land can't already be overgrazed. Okay, so now you file your application, and the agency isn't sure whether it should grant it or not. So they ask you in for a meeting, and they say, let's talk about this, because it would be the quintessential execution law to grant you or deny you your permit. So now they call you in for a meeting, and they invite someone from the enforcement office of the agency to sit on the other side of the room. And you give your presentation about why I should get it, and they give their presentation about why you shouldn't get it. That's not adjudication. That's execution of the law. They happen to be using an adjudicatory form to do it. Now suppose the agency wants to let people know in advance, what does it mean to have the land overgrazed? Because Congress said overgrazed. So now they put out a little statement that says, overgrazed means less than XYZ density of growth. I don't know anything about grazing, but less than a certain density of plant life in the field. That is not legislation. That is that agency executing that law that Congress gave it the power to execute. Okay? And now, and I think that's what Justice Scalia meant when he said that there is no delegation of legislative power at all. And Justice Stevens disagreed and said there is a delegation of legislative power. I happen to be with Justice Scalia on this one. So let me just finish up by saying, what does that mean about Chevron? Okay, so now the question in Chevron and about the jurisdiction of an agency, in my view, every single question is jurisdictional. And that's why the Chief Justice was wrong and Justice Scalia was right in the city of Arlington. Because the question, what happens if an agency tries to enforce something against you, in order for them to do something to you, even if you can't get judicial review of the rule, because Congress has said no judicial review of these rules, if the agency tries to issue an order against you and do something to you, you can go to court and try to stop the agency from doing that to you. And in the course of that proceeding, your defense is that the agency did not have authority to do this to you because they haven't been delegated this power from Congress. Either because Congress told them statutorily to do it something different, or because Congress said you have to do it reasonably. In this case, they didn't do it reasonably. And so the question in all cases is ultra vires. That is, has Congress delegated the authority to the executive branch to do this to you? And that's a jurisdictional question in every single case of administrative law. And that's why the city of Arlington is correct.
Thanks very much. It's great to be back here again. I have been here since 1981, I think. Let me start with a brief biographical note. I think my first serious involvement with Chevron was when I was working in the government as Deputy Solicitor General. I was in charge of the civil division of the Justice Department, which represents the various federal agencies. And after about a year on the job, I told my friends that I was actually the Deputy Solicitor General for Chevron, because every single case that came up from the civil division involved some Chevron issue. And the government was obviously thrilled with Chevron and was trying very much to make it as secure as possible, avoid any types of trimming back. And so they were kind of worried about the Supreme Court. We tried to keep these cases out of the Supreme Court because we were apprehensive at that time that maybe the court would trim back on Chevron. After I left the government, I started reflecting on my experience, and I quickly came to the conclusion I was an academic again, so I was a little bit liberated from my client obligations. I concluded that Chevron was a bad idea. I actually wrote a little essay, it's buried in some magazine somewhere, called Confessions of a Chevron Apostate, in which I said that although I'd been Deputy Solicitor General for Chevron, I no longer thought that Chevron should be good law. And the first couple, I've written about 8 articles on Chevron. It's kind of an embarrassing thing to disclose, but we all have to do something for a living. I think the first 2 articles I wrote in the early 90s, shortly after I finished being Deputy Solicitor General, essentially argued for the overruling of Chevron. I thought it was basically a very flawed doctrine, a bad idea. I guess if I had to summarize it, I would say that it's faux formalism. It sort of looks on its face like a formalistic doctrine, step 1, step 2, so forth. You can organize opinions and briefs very nicely around Chevron. I think that's one of the secrets of its success. But what are the steps? The first step is clear or not clear, and the second step is reasonable or not reasonable. And those are not rules. Those are the biggest, squishiest, fattest standards you can imagine. And by sort of suggesting that the entire realm of judicial review of agency interpretation can be funneled into those 2 concepts, I think produces enormous confusion and enormous disutility. Now, I want to say something nice about Chevron because no one else has said anything nice about Chevron. I do think that Chevron deserves credit for, I think, planting the idea in our jurisprudence that in some situations, cases of statutory interpretation are actually cases about policy. They're not just cases about meaning or how to construe a statutory enactment, and for suggesting that when, in fact, the case of interpretation becomes a case of policy, there are some strong reasons for preferring administrative or executive interpretation rather than judicial interpretation, namely the accountability, greater accountability that agencies have through their responsiveness to both the Congress and the President, elected officials, and also their greater experience and expertise. Now, that's not to say that Chevron does a very good job of telling us where the line is between interpretation and policy. It doesn't do a very good job of that at all. And that's generated enormous disputes and so forth. So, but I did want to say one nice thing about Chevron. Now, I think, why do we have judicial review of agency action? You know, we have a number of reasons for that. Maybe it's not required constitutionally, except in cases of private rights, but it serves a number of useful functions. One of them is to protect individuals against bureaucratic arbitrariness. That's pretty important. One is to sort of try to encourage agencies to be more accountable by explaining the reasons for their decisions. That's pretty important. But I would submit that one of the most important functions of judicial review is to maintain and police the boundaries between different governmental actors in our system. Now, Jack is right that Congress doesn't have to create judicial review in order to help maintain and create police boundaries, the outer limits of agency authority and so forth. But the reality is that Congress has consistently done that, and I think they've done it precisely because they perceive that judicial review is helpful in making sure that agencies don't start running amok and engaging in regulation where Congress never contemplated that they would actually have authority to regulate. But it's not just a matter of delegation. It's not just a matter of the delegated authority of the agency. There's a bunch of other important boundaries. There's the Constitution, for example. We don't want agencies violating people's constitutional rights. There's the question of one agency usurping the authority of another agency or another entity of government. There's a very important question of federalism. We don't want federal agencies running roughshod over the traditional prerogatives of the state and local governments. All these boundaries are very important, and I think the function of judicial review in critical respects is to try to maintain stability in these boundaries. Now, the court in Chevron didn't say anything about boundary maintenance because I think they perceived the question in Chevron, which was the meaning of a stationary source of air pollution, was clearly within the ambit of the EPA's authority, so there wasn't any boundary maintenance issue to be resolved. Later decisions like Arlington have brought this question to the fore. So I think there are three ways in principle that you could engage in boundary maintenance through the lens of the Chevron doctrine. Step 1, Step 2, and what has come to be called Step 0, or the preliminary threshold inquiries into whether or not the agency has been given sufficient authority to have its interpretations reviewed under Chevron as opposed to Skidmore or something else. Now, the court has sometimes used Step 1 to engage in boundary maintenance. I would remind you of the case of FDA versus Brown and Williamson tobacco, which was the question of whether or not the FDA had authority to regulate tobacco products. And the court purported to apply Step 1 in answering that question. It wrote 29 pages about all the testimony that various FDA commissioners had made over the years and how Congress had responded by giving the Federal Trade Commission certain authority and so forth. And after 29 pages of this excruciating analysis, the court said, it's clear that Congress never gave the FDA authority to regulate tobacco products. So that has happened. Another possibility is to regulate boundaries under Step 2, where you ask whether or not the agency's interpretation is reasonable. You could say that a boundary violating agency action is unreasonable, and Justice Scalia did that just quite last term in the case involving the interpretation of the PSD provisions of the Clean Air Act, which I'm going to come back to. Another third option, which is basically the one that was rejected in the city of Arlington, is that courts could ask before they get to Chevron, as part of Step 0, if you will, is the issue before us one in which the agency's been given delegated authority to act with the force of law? And courts could decide using independent judgment whether or not the agency is exceeding its various jurisdictional boundaries, legislative, separation of powers, constitutional and federalism boundaries at Step 0. This was, a version of this was endorsed by Chief Justice Roberts in his dissent, but Justice Scalia, speaking for Justice Thomas, and the three most liberal justices on the court disagreed and said, as some of the other panelists have described, that agencies in cases of ambiguity get to decide their scope of their own authority, a proposition I find utterly astonishing. None of these three options, I think, are very satisfactory. To illustrate, let me talk briefly about an issue that I think that any sort of reasonable person, fair-minded person, would have to acknowledge pertains to the questions of the legitimate boundaries of agency action. This is the question of whether the EPA has authority to adopt an aggressive and wide-ranging program to regulate greenhouse gases in order to combat climate change. Okay? So, in fact, we do have some confrontations with this under Chevron. The first one occurred in 2007 in a case called Massachusetts versus EPA, in which the Supreme Court essentially addressed this issue under Step 1 of Chevron. The question in that case was whether or not EPA was required to institute a rulemaking to decide whether or not to limit tailpipe emissions of motor vehicles in order to reduce greenhouse gases. There was an agonizing standing debate in the case and so forth, but eventually the court decided that Massachusetts had standing because, you know, a millimeter of land might have disappeared because of rising oceans. And it went on to rule that, in fact, EPA does have jurisdiction over global warming and greenhouse gases. And the reason it gave was unfortunately rather not untypical for a Step 1 decision. It focused on one little provision of the Clean Air Act, which was a definition of the word air pollutant. And it interpreted that one little provision under step 1. The language says that an air pollutant includes any physical, chemical, biological, radioactive substance or matter which is emitted into or otherwise enters the ambient air. And the court said, well, you know, carbon dioxide and so forth enters the ambient air. It's a chemical. Therefore, greenhouse gases are air pollutants. Therefore, EPA has authority to regulate greenhouse gases. Therefore, EPA has to consider this rulemaking petition to regulate tailpipe emissions in order to limit climate change. That was kind of ironic in my view because it was the kind of wooden literalism that liberals are constantly accusing some textualist conservative judges of engaging in. I think wrongly. I think textualism is much more sophisticated than that. But in this case, a coalition of justices led by Justice Stevens, and including the liberals and Justice Kennedy in a weak moment, decided to engage in literalism in order to force the Bush administration to get on with it and start regulating climate change. I think that was the message being sent in that particular case. So here we have step 1 being used by a court to resolve a jurisdictional issue in favor of the agency. The Bush administration was arguing that it didn't want to regulate. The Supreme Court says, no, you have to regulate. So the jurisdictional issue is resolved under step 1 in a fashion that I think was virtually mindless. If anybody who knew the Clean Air Act would be consulted about whether or not greenhouse gases can be regulated meaningfully under the Clean Air Act, the answer would be, this makes no sense whatsoever. There are all sorts of provisions in the Clean Air Act that would be nonsensical. Under that understanding, the most central is that the Clean Air Act requires the designation of certain critical pollutants that are regulated by ambient air quality standards. And when a pollutant is designated as such, it has to be reduced so that it has zero health and zero welfare effects. Well, it's literally impossible to regulate greenhouse gases, so it has zero health and welfare effects because we have no authority over what most of the world does in the way of emitting greenhouse gases. Okay, so that was step 1. The next inquiry, what about step 2? So the next confrontation with greenhouse gases occurs last year in a case called Air Utility Group, in which the court considered regulations that EPA had promulgated under what are called the Prevention of Significant Deterioration provisions of the Clean Air Act, which is designed to prevent states from allowing their air quality to deteriorate down to the level of these national ambient air quality standards. And EPA, in an exercise of extraordinary contortion, had interpreted the PSD provision to say that, well, greenhouse gases are pollutants, and PSD says that the PSD regulations are triggered when any pollutant above a certain threshold is emitted, and therefore, if somebody's emitting enough greenhouse gases, they have to comply with these new regulations under the PSD program with respect to new sources. So the little problem that this presented was that the PSD provisions have numeric thresholds for how much pollution you have to emit in order to be subject to these regulations, and the threshold is a little bit complicated, but it's basically 100 tons of pollutant a year. If you made every source that emitted 100 tons of pollution a year file a PSD permit and comply with regulations, every apartment house, every school, every restaurant, every dry cleaning shop in the United States would be subject to the PSD program. So recognizing this, EPA decided that it would change the 100 ton per year threshold in the case of greenhouse gases to 100,000 tons per year. And so with that little trick, EPA then decided that, then promulgated these regulations. Justice Scalia, writing for 5 justices, held that this was invalid. He said that, in fact, the definition of pollutant for PSD purposes has to mean everything but greenhouse gases. How he got around Massachusetts versus EPA is a little unclear, because Massachusetts had said that pollutant requires that you include greenhouse gases. But Justice Scalia said that, you know, a pollutant is ambiguous. EPA's interpreted it differently under different sections, so it must be ambiguous. He didn't say that, you know, step 1 was violated, obviously, because he said it was ambiguous, but he said it was unreasonable, and it was unreasonable primarily because you can't rewrite the statute. If you interpret the statute in such a way that you have to rewrite part of the statute to change 100 to mean 100,000, that's unreasonable. And he got 5 votes for that. Actually, 2 other, Alito and Thomas also concurred in that. So you might think, this is a victory, right? Let's use step 2 to police the boundaries of agency action. Not quite so fast. The opinion then goes on to discuss another aspect of the EPA regulation, which was that if the source emits over 100 tons of some other pollutant which is regulated, then it has to comply with greenhouse gas emission controls. And Justice Scalia apparently didn't have the votes or didn't want to invalidate that regulation as unreasonable. And it turns out that that second regulation covers 97% of the relevant sources that the EPA wanted to regulate under PSD. And so the victory on the first part of the case was symbolic, and the government regards this as a major victory. What about using Chief Justice Roberts' proposal in Arlington to police the boundaries of agency action under step 0? Actually, I think this is the best of the 3 possibilities, but I'm not very optimistic either here if you think about, again, EPA and the Clean Air Act and climate change. Chief Justice Roberts basically said that the way to try to do this under step 0 is to require that you show that the particular issue in question is one as to which the agency has been given authority to act with the force of law. So you would not just look at a generic rulemaking grant, you'd look at the specific section of the statute or the clause and see whether or not there's a rulemaking grant there or an exception to rulemaking power in that particular section. The problem with this in terms of the EPA and the Clean Air Act is that virtually every section of the Clean Air Act includes a rulemaking grant to the EPA. So it doesn't really matter whether the EPA is trying to rewrite regulations under the stationary source provisions, section 111D or PSD, or the non-attainment sections or the mobile source provisions. They all have rulemaking grants. They all authorize EPA to regulate with the force of law as those grants are currently understood. And so it may be that even if Chief Justice Roberts' approach is ultimately accepted, it wouldn't do much in the way of giving courts authority to police the boundaries of agency authority. What's really needed is not Chevron step 1, 2, or 0. What is needed is an inquiry at the outset of the case that asks honestly whether the entire statute, in the context of its historical enactment and development, is one in which Congress gave the agency authority to regulate the phenomenon in question. Courts should be engaging in independent judgment about this issue without trying to sandwich their inquiry into the shackles of Chevron. Filtering the inquiry through Chevron has made it significantly more difficult to reach the honest answer about these questions, and in this respect, I think Chevron is contributing to a distortion of the form of government given to us under the Constitution and threatens to undermine the boundaries that have been so carefully nurtured for most of our history. Thank you.
Well, this has been a very genteel and well-mannered panel. Does anybody want to cause a ruckus or take any gloves off before we go to the audience for Q&A? Chuck, you're always game for that, right? Nobody has any kind of rebuttal or impertinent questions for your fellow panelists?
I'm not going to take the gloves off here, but I am going to ask or make an observation, I guess, about Professor Bierman's very forceful and elegant discussion about how the executive agencies, administrative agencies, exercise only executive authority, no matter how much the activity that they're involved in, the function that they're involved in, may quack like a legislative function, or it may quack like an adjudicative or judicial function. It's nonetheless an executive function, and it puts me in mind of Justice Scalia's observation in footnote 4 of the Arlington case, where he criticizes Chief Justice Roberts' observation, much like mine, that the administrative agencies are exercising legislative and judicial power. And he says the dissent, this is from the footnote 4, the dissent overstates when it claims that agencies agencies exercise legislative power and judicial power. Agency activities take legislative and judicial forms, but they are exercises of, indeed, under our constitutional structure, they must be exercises of the executive power. Well, that assertion just isn't very satisfying to me. Yes, it is true, I think, under our structure of government that executive officers and the president can only exercise executive powers. But I don't think that fact means that any power they exercise is therefore an executive power, no matter what it really is when you analyze it in terms of its actual function. And again, I think Chief Justice Roberts was right that separation of powers restrictions do apply here. And I guess I want to conclude by asking a question, and that is, what do my fellow panelists think about Chevron Step 1 in light of the Arlington decision? How will Justice Scalia in the future, as he approaches Step 1, using the ordinary tools of judicial construction, as he says, decide correctly, attempt to decide a judicial question correctly whether or not the provision at issue is ambiguous in light of Arlington's decision that says the question of ambiguity, that is, if that's the source of the agency's authority, the question itself of ambiguity, if it is ambiguous, then we must defer to the agency itself. Isn't Step 1 now collapsed?
Oh, I agree with that, basically. I mean, I would put it in terms of the Administrative Procedure Act, actually. A lot of people have pointed out the Administrative Procedure Act requires courts to decide all relevant questions of law. And then they say, well, if that's the law of the land, where do we get Chevron? Now, there is an answer to that, which is that, you can reconcile Chevron with the APA by saying that Chevron rests on a determination that Congress has, implicitly at least, delegated to the agency the power to resolve ambiguities under this particular statute. And so the court, by deferring to the agency, is in fact following the law that Congress, it's interpreting the law and following the law that Congress has laid down. The problem is you can't extend that argument to the question of whether or not the agency is acting within the scope of its jurisdiction. Because the whole premise of reconciling Chevron with, the requirement that the courts decide questions of law is that the agency has been delegated authority to decide these questions of law. But that question can't be answered by the agency. It has to be decided by the court. And the APA actually explicitly says that questions of whether the agency is acting within the scope of its jurisdiction are for the court to decide. It says that in so many words, not quoted anywhere by Justice Scalia in Arlington.
Anyone else want to chime in?
I think I've already had my 2 cents on that.
Okay. Professor, anything? Okay, there's a staggeringly long line at the microphone. If anybody, there you go.
Is this thing on? It is. Okay. Can I ask the panel whether they think that it's just a coincidence that Chevron is a Clean Air Act case? I'm inferring from Professor Merrill's remarks that he does not think that that's a coincidence. And I want to frame it a little more and say why I ask that. 2 reasons. One, we have the 2 competing justifications for deference, one of which is the implicit delegation, the other is agency expertise. It seems like the latter has gone more and more by the wayside over the decades. But if you go back and reread Chevron, it is impossible to escape the impression that part of what the court is doing there is saying, we're lawyers, we're not scientists, right? That seems now to have fallen by the wayside, and actually in the EPA rules, which Professor Merrill alluded to, that will be subject to a great big nasty Chevron fight eventually in the courts, the EPA is demanding deference for legislative history and things that look nothing like its technical ambit, right, that it has zero specialty in. And then the other question I want to ask is very briefly, the part of the formulation that always drops out is under-theorized, as far as I've been able to tell, has no definitive academic or court statements on what it means is a statute that it has been entrusted to administer, right, whether it's your statute to talk about in the first place. Again, EPA is making certain claims that it now has deference to interpret energy acts, right, that have nothing to do with EPA and are not entrusted to it at all. And so do people, does the panel see there's any possibility in 30 years later, or 33 years later, however long it takes us to actually get there in the courts, that there may be these power plant rules may lead to not just tinkering around with the Clean Air Act, but another whack at sort of the roots of Chevron?
Who wants to tackle that?
That sounds like a question for Professor Merrill.
Okay, all right. So, no, I don't think it's a coincidence that the environmental area was where this doctrine emerged. I actually wrote one of these 8 articles I wrote is a kind of a history of how the Chevron doctrine came to be, and I went back and read the notes from the Supreme Court's deliberations about the Chevron doctrine. Justice Blackmun kept rather meticulous notes, and they're in the Library of Congress. Anybody can go look at them. And it was quite interesting to read the notes about the conference in the Chevron case. I don't think anybody understood anything about what was going on in that case. They made all sorts of nonsensical statements about what various lower court decisions had decided about stationary source regulation under non-attainment and under PSD and so on and so forth. Finally, Justice Stevens, who was then, I think, the second most junior justice, spoke, and he said, he gave a slightly more cogent explanation of the issues, but then he said, I'm just really confused. And he said, when I'm confused, I go with the agency. And then he got the assignment to write the opinion from Justice White, and the rest is history. So I don't think it's a coincidence. I think that there is something about hyper-technical, difficult to comprehend statutory interpretation questions that is likely to incline the courts to want to turn this over to somebody that's a little bit more capable of answering these questions in a coherent way. That's, EPA is sort of ground zero for that. There are a bunch of other agencies, like the Federal Reserve Board and so forth, that also decide things that are highly technical and beyond the ken of most judges. That's a very realist explanation for when judges defer and when they don't, but I think there's a lot of merit to it.
Anyone else? Mr. Hayes from the Lone Star State.
Yes, sir. Thank you. And this question comes in part from many, many years spent in the trenches dealing with administrative agencies day to day, practicing law. And it strikes me that to some extent the elephant in the room may be, and I'd like to hear the comment as to whether you think it is or not, what might be called the myth of administrative expertise that has been alluded to here. But certainly, my experience, I often find that the agencies either don't have the expertise, either technically or from a legal standpoint, or if it is buried someplace in the large bureaucracy, it's not brought to bear on the particular rule or question that's addressed, and that indeed we frequently neglect the fact that there are many institutional factors driving these very large and often sprawling bureaucracies that denigrate from any expertise that might be there. And I find that aspect of these discussions seems to be neglected in favor of, for instance, I think very good thoughts on the separation of powers issues and others issues. Thank you.
I'll take a quick stab at that. There are questions where the agencies seem to have a lot of expertise and questions where they don't. For example, in this issue about the subsidies under the federal health care exchanges, I don't think the agency, everyone believes the agency when they say that the whole system's going to fall apart if they don't have the federal, subsidies for the federal plans. So that's not much of an expertise issue, and it's one of those sort of delicious law school type statutory construction problems. The question under the Clean Air Act that was at issue in Chevron is clearly a matter for agency expertise, and the question is comparative expertise. That is, you get a question which is right in the agency's wheelhouse, and they're, unless you think it's the agency is just, always engaged in raw politics and you shouldn't defer to them at all. If it's right in the agency's wheelhouse, then who's going to know better, the court or the agency? And chances are, in many situations, not all, but in many situations, the agency is going to know better. And on the top of it, it's not like the courts are applying expertise and legal reasoning or some sort of thing when they decide these cases. They're deciding it based on where on the political spectrum the particular case falls. The courts, it's not a surprise when the 5-4 cases occur. You know, going back to my umpiring, I found it insulting to say that the Supreme Court behaves like umpires. That when Chief Justice Roberts said that, because if we walked on the field and people knew how we were going to decide in advance of the game, we wouldn't be allowed to umpire.
Anybody else?
I'm going to add just a little bit to that, and I know drawing on Seminole Rock is a little different, but it seems to me that you do see in the context of deference doctrines, if you look historically, again, looking at very modest roots, and you think about expertise as driving some of those decisions, which it seems very clear that they were limited in that way. It is also clear that we have a very big expansion of those deference doctrines, and part of what has changed is moving away from thinking about when the agency is truly acting in an area where it really does have special expertise versus some other sort of justification for their act.
This will be our final question. Gala time is almost upon us, and some of us need more time than others to get gussied up and prepare. So
I promise I'll be brief.
I got to tie that tie. Go ahead.
Do you have a bow tie? It took a while to read the directions on it. All right. I'm Mike Doherty. Many of you might know that I'm embroiled with the LabMD versus FTC case. I'm the CEO of LabMD. My question is really, and I'll backfill it a little bit after I ask it, what's it going to take? What are the circumstances it's going to take to get rid of Chevron? Because I will tell you, my experience as a layperson and a CEO and as an American, is I had certain expectations of how this country was run, what my rights were, and the power that the agencies have are dumbfounding to every other business professional I've talked to that I've gone through this meat grinder on. The fact it is a mountain of power that costs millions of dollars of years to climb that most people won't do. So you never get to the courts for them to actually get rid of this craziness that shocks people. The fact that I wasn't allowed to come to some of my hearings. The fact that the games the FTC plays when the Oversight Committee finally started an investigation and the Legislative Affairs Office is doubling down with senators jumping in. It is appalling behavior in the specifics. So what's it going to take to get someone to climb up that mountain enough to actually get this thing turned over at least and the details get put on the public?
So appalling and craziness, does that overstate it, or is that a G-rated description?
So, you know, the interesting thing, of course, is if you remember back in the history, in 1980, there was rumblings about the non-delegation doctrine. Of course, you know, that if you take my approach to Arlington, if there's a more sort of robust either review of delegations or a more robust non-delegation doctrine, you don't really have this problem so much because the agencies wouldn't have so much discretion, and so there wouldn't be so much to defer to. In 1980, it seemed like, you know, sort of more stringent judicial review of what statutes said in order to make sure there wasn't too much of a delegation seemed like a good idea. Suddenly in 1984, it seemed like deference was a good idea. And what changed between 1980 and 1984? And I think there was a deregulatory president, you know, came into power in 1981, and suddenly deference to agencies seemed like a good idea. Well, after 6 years of the Obama administration, maybe it doesn't seem like such a great idea anymore.
Isn't that ironic, by the way?
And, you know, it may seem like a good idea in a couple of years, but I sort of doubt it based on the demographics of the Electoral College. But, you know, it's, so really, it's, I know that my colleague Gary Lawson said that even at the beginning, there were some people among the Federalist Society that were concerned about Chevron, that it was too deferential to agencies. But it's really, it really is I agree that it's fundamentally wrong for courts to be that deferential to what agencies are doing. And I think it's the biggest reason I think it's fundamentally wrong is because the APA says that they're supposed to engage in judicial review under the arbitrary capricious standard, and they should be. And it encourages lazy behavior by agencies who can ignore what Congress says because they figure they might get away with it. And it encourages laziness and sloppy behavior by judges who can, at the lower court level, they can just get rid of cases. It's a little bit like the administrative law equivalent of non-exhaustion of your habeas remedies on the criminal side. You know, it's a way to get rid of a lot of cases without having to really engage in the hard questions about what does the statute really mean. So I tend to agree with you, even though I don't share, I think, your approach to how much regulation we ought to have. I think whether it's a deregulatory regime or a regulatory regime, it never seemed right to me.
One thing that struck me lately is that, we've been talking about questions of law and who should be deciding questions of law, but I think for a lot of people, that's less important than getting the facts correct. And you can go way back to the early 20th century, and federal judges decided that, reviewing fact-finding by agencies was something that they were too busy to do. And so they developed this kind of substantial evidence standard of review of fact-finding by agencies, which essentially meant that anything that the agency did got rubber stamped as long as they had some smidgen of evidence in support of what they were doing. And only later, with Chevron, do we start debating about whether or not courts should defer to agencies on questions of law. But I think for many people, the greater injustice is the agency's manipulation of the facts. And the fact that you can't really go to federal court. One thing courts are good at is fact-finding. I'm not so sure they're good at, policy-making, but they're pretty good at fact-finding. And I think the hands-off approach to that may have contributed a lot to frustration.
Any final word? No? All right, I want to thank our panel. This has been lively. Thank you.
Pretty good crowd, actually. Yeah, it was